Good afternoon, dear professors, dear guests. It is a great honor for us to host you in the second seminar of Comparative Law Seminar Series. Welcome all, and thank you for being with us. We have very distinguished guests, professors, colleagues, and students today. And I see also Professor Borghetti. He honored us as our first guest in the Comparative Law Seminar Series a few weeks ago. Bienvenue, Monsieur le Professeur. And today we will listen to Professor Kyriaki Noussia's presentation on COVID-19 and insurance law implications. This event today is co-organized by KHAS University Faculty of Law and KHAS University Liability Law Research and Practice Center. So I would like to give the floor to Associate Professor Dr. Nilay Arat. She is the director of the center, and then we will listen to Dr. Noussia. So please, Professor Arat.
Okay. Thank you very much. It's again my great honor and pleasure to welcome you all, our distinguished colleagues and our guests, our students, to the second of Comparative Law Seminar Series, jointly organized event of KHAS University Faculty of Law and the KHAS University Liability Research and Practice Center. We have started our Comparative Law Seminar Series with our honorable guest and distinguished colleague, Professor Borghetti, and now holding our second with our Greek friend, Dr. Kyriaki Noussia. Having been a part of European Public Law Association, which has its premises in Athens, I have personally been very much close to Greek community of legal scholars, maybe for almost 2 decades. I have also personal experience of teaching at the University of Athens in graduate level courses. In total, all these academic collaboration and bonds make me feel more comfortable today to host a Greek friend in our Comparative Law Seminar Series. If you allow me, I would like to offer a few words as regards to our special guest today. I would like to extend my warmest welcome to our guest, our distinguished colleague, Dr. Kyriaki Noussia from Exeter University. After having her law degree from University of Athens, Dr. Noussia got her LLM from University of Essex on international trade law and a PhD degree from Southampton University on marine insurance law. She has been very much active in teaching and researching worldwide, as she has been a visiting scholar at various universities like in Australia, in the United States, China, Italy, France, Germany, Greece, and also Turkey. Dr. Noussia is also contributing to practice through international and regional societies by taking active role in insurance law associations and conducive toward the development of the legal science. Her main focus areas and research areas are insurance and reinsurance law, private and public maritime law, arbitration law, and environmental law. Today, Dr. Noussia is going to speak about the COVID-19 and insurance law implications. Dear Dr. Kyriaki Noussia, I leave the floor for your valuable contributions. Again, thank you for honoring us here today, please.
Thank you so much. Let me share my screen. So before I start, I would like also to extend a very warm thank you and welcome thank you first of all to Professor Bashak Baizal for inviting me, and to everyone in the KHAS University, and also to Professor Arat for making this kind introduction for me. So I am here wearing my double hat, as we say in English. So I am an UK academic because I belong to the University of Exeter, but I'm also a continental lawyer because I have been trained at first degree at the University of Athens. So I think I'm one of the few people that know both, well, not one of the few, but let's say one of the people that know both systems well. And I try to do that in my research as well. So I'd like also to welcome all the attendees. And I heard from you that Professor Borghetti is also present. Welcome as well. So today I'm going to talk to you about the insurance implications from the pandemic, from the coronavirus COVID-19. But before I go, I decided to talk a bit about, because we co-authored with Professor Baizal an article on the contractual implications. So I'd like to talk a bit at the beginning about the frustration and about whether we have force majeure actually in relation to the performance of contracts, and then move to talk about the insurance implications and mainly the business interruption claims that have arisen worldwide since the pandemic started disrupting the performance of contracts and the performance of businesses last year. So as you know, or as you may know, coronaviruses have always existed in our environment. They are not something new. However, the new novel coronavirus, which was dubbed as COVID-19, emerged in 2019 and was identified and has led to a worldwide pandemic with huge healthcare, medical, as well as financial impacts for humans, for their health, and for the society. Since the big outbreak in the continent of Europe last spring, we have waves and mutations of this virus which have kept coming and going in the last year in different pace and time lengths in the different parts of the world. And they're unfortunately continuing so far, which means that we are at the end, but let's say we can see the light in the tunnel, but we are not at the end yet. And in light of all that, different governments around the world have, from time to time, declared lockdown measures in order to restrain and halt the virus's spread. Whilst recently, as of December 2020, vaccinations have now started. Now, this government shutdown of businesses for intended periods of time to contain the virus has practically meant that the companies have been unable to perform their duties and obligations under various contracts. And therefore, this, as I said at the beginning, has had a lot of repercussions in relation to whether we have breach of contract or frustration of contract or force majeure. And in addition, insurance mechanisms that have been in place, for example, the business interruption policies, they have triggered claims automatically, which in some cases the insurers paid, and in some other cases the insurers denied to pay, and therefore the policyholder, the assured, would resort to court. Now, with regards to commercial contracts, the main question is whether COVID-19 constitutes a force majeure event. And this, as you know, in law depends mainly on the definition of force majeure in each specific contract. And the biggest and the better certainty and justification for saying that we have such a force majeure operation will happen in cases where in the contract we have a detailed force majeure clause. I usually tell my students when I teach, so in this semester I teach arbitration and investment arbitration, both at LLB and LLM level, and I tell them that the more detailed the dispute resolution clause is, the better protection you have. The same is for every clause in a commercial contract. Now, in commercial contracts, we have force majeure described and defined or not, and where it is described in detail, it may also list the contract, the clause, the relevant clause may also list certain examples. So it can say that force majeure includes epidemics, pandemics, or acts of government, which all of them classify as what we say usually also in common law, acts of God. Or in contrast, they may exclude such terms. Now, in the context of COVID-19, the question was whether we had an inclusion or an exclusion. And if such terms are included, a party can argue that the pandemic is an act of God and therefore it constitutes force majeure. And they can also argue that the government restrictive operational measures, for example, the from time to time lockdowns, are acts of government equal to force majeure in effect. Now, I'll jump a bit into the continental law, and I'm deriving now my knowledge from Greek law to say that Continental law is a bit more flexible or not so strict as common law, and it allows commercial impracticability. When we have this notion of commercial impracticability under the civil code, we allow the parties to go into the court to justify court adjustment of the contractual performance obligations and rights based on the justification of what will be classified by the court as a force majeure in extreme cases, for example, during pandemics or during or after extreme economic dislocation, like, for example, world wars. And where a party relies on such a force majeure clause, compensation depends, of course, on the wording available, and the cases for such compensation may include temporary suspension of the contract during the period where the force majeure event persists, or the extinguishment of any liability arising from any delay or non-performance, the right of either or both the parties to terminate the contract, and the automatic discharge of the contract, which brings to the end the obligation of the parties. Now, that's the easy bit. The difficult bit is, and the question which arises is whether in the absence of a force majeure clause in a contract, or if there is such a clause, but it fails to correspond to the compensation of the party in suffering, the contract could be frustrated. Now, frustration is a very peculiar beast, I would say. A contract may be frustrated where an event occurs after the contract has been exchanged that makes it physically or commercially impossible to complete the contract. And the contract alternatively could be frustrated where the obligations become significantly different from the ones that were agreed when initially the contract was entered into. And if you are a bit aware of the common law case law, the doctrine of frustration was established in Taylor versus Caldwell. I've put the reference there in the slide as an exception to the general rule that if performance of a contract becomes more difficult or even impossible, the party who fails to perform the contract is liable to the other for damages. Now, what the doctrine aims to do is to avoid injustice where neither party has done anything wrong, and it's not their fault that the contract is now impossible to carry out. But however, that said, in practice, it's very difficult, or it is difficult to establish that a frustrating event has occurred, and that frustration is listed as encompassing events where, for example, we have a contract where due to an event which has occurred, neither party is at fault, but neither party can perform, where the event is beyond what the parties contemplated or thought at the beginning when they entered into this contractual relationship. And this, let's say, event is so fundamental that we say in common law, it touches to the core of the contract, that it alters the initial character for which the contract was articulated. Or it renders the performance of the contract impossible, illegal, or, as I said, radically different than what the parties contemplated in the first place, or where the subject matter of the contract is no longer available, or where we have a subsequent change in law or in circumstances that make performance illegal. Now, if you look at Taylor versus Caldwell, if you take the time to go into the reference I have said and read the case, you will see that you will conclude that under English law, early cases allowed an excuse from performance obligations through the insertion of an implied condition regarding the continued existence or future occurrence of a state of affairs. But later on, as English law and the case law evolved, the true rationale of frustration was depicted, and the body of case law in the common law world became very strict in its interpretation. And this is also one of the reasons why, if you wonder why England and commercial law in England is so dominant worldwide and so preferred, is because the parties look for certainty. They look for a rigid system which will allow them contractual performance. And English law does that. English law allows exceptions, but the judges are very strict in how they would allow these exceptions to occur. So justified contractual non-performance is allowed in England under the English court's judgments, but it is more decided on a case-by-case basis, or this is the pattern we have seen right now. And in a minute, when I go into the insurance case law from all over the world, you will see how this case law has evolved over the last year. So under the English law of contract, commercial impracticability of performance which is a very valid reason under Greek law, I believe also under Japanese law, because I read an article by a colleague who said that this notion was used by the parties after the World War II. This is why I said before, during extenuating circumstances and events like world wars. So under continental law, you have this notion, you have a provision in the Civil Code for commercial impracticability. That doesn't serve under English law. If we have an unclear meaning of the force majeure clause in English law, the courts will follow the traditional route, the usual rules of contractual construction. And what the courts do, the judges, the common law judge does, is to consider that the words, what is that natural and ordinary, the plain and intelligible meaning of the words. Now, I said before at the beginning that an act of God will usually mean an event which is due to natural causes without human intervention and may well cover or not cover an evolving situation like a pandemic. Now, the good thing about continental regime is that because of this notion of the changed circumstances of commercial impracticability, it allows non-performance if we have a substantial change in the circumstances. For example, as I just said, economic crisis after wars, affecting the basis of the contract, or whatever may change the core of the contract, such as the cases now under a pandemic. And these extraordinary grounds must affect events relating to what the parties expected to conclude the contract. So you can't just go and say, I do not want to have the obligation to perform my duties under the contract just because COVID-19 has occurred. You have, as a person claiming that, to be able, as a claimant, to be able to prove that the emergence and the occurrence of the COVID-19 pandemic has actually incapacitated you by and large in performing under the contract. Now, this as a general introduction, I could talk for hours about contract law and frustration and force majeure. I'd like to talk now, I thought that it was important to make this, let's say, introductory analysis, but by all means, this is not a deep analysis, but I thought it was good as an introduction so as now to move to the more specialized area of insurance and more specifically business interruption cases, which have arisen on the basis of, as a result, or because of the occurrence of COVID-19. Now, for those of you who may not be aware, business interruption insurance, as the term says, business and interruption. So it covers financial losses due to the loss of revenue because of non-operation. Such insurance is usually bought as a standalone cover or part of a property policy. And those who said that COVID-19 is not a cause to trigger such a claim, they argued that we have no causation, as you know, which is required in law because there's no damage to property. This has to have, the trigger event will be a damage to property. Now, they said that the pandemic doesn't really justify or prove any damage to property, and without such damage to property, the business interruption insurance claim would fall short. And this was the rhetoric of the insurers and of academics all over the world last year. I have to tell you now, I'm very proud that I was one of the first that previewed in early March last year that there will be a tsunami of claims for business interruptions. And a lot of colleagues told me, no, this is not going to happen. There is no causation. And I think I was proven sort of right so far. So if we have, how can we justify this damage to the property? More specifically, to break it down to simple language, even for non-lawyers. If we have an order by a public authority that the shops have to be closed, does this order constitute a causation for the rise of a claim for business interruption, for coverage, as we say in insurance, to exist? Now, what the policyholder, the assured, has to prove is that he had some sort of physical loss or damage to their property. And this can change over time because the pandemic circumstances, the pandemic data that we had changed over time. And the changing circumstances may allow for the insurance coverage to be extended and to be more expanded. And the courts have held that contamination, just to give you a first idea, that attaches to the property or physically affects the property so that it renders the property uninhabitable or unfit for its intended commercial purpose, can constitute physical loss or damage. So pre-COVID also, if you could prove that you had some sort of contamination that attaches to the property, affects it, and makes the operation not feasible, then you had proven the causation threshold in order then to say that you have a claim for business interruption. And usually we would have business interruption policies, I will say that in my conclusions, through extensions such as disease or inability to reach the property operating. Now, I'd like to say here that in the US, the environment was very hostile, in quotation marks, hostile towards the policyholder, the assured, at the beginning of at the onset of those claims. So in March 16, 2020, we had an executive order issued by the New York City state, at state level, not at federal level, which addressed the threat of COVID-19 and expressly found that the virus physically is causing property loss or damage. That was a very welcome note, let's say, for the policyholders, but it didn't all the time mean that the courts would follow that. So what the advice was that the policyholder have to look at their policies, look at your contracts, is what was stated at the beginning, to look what is covered. And therefore we see here again and again, it's a live example of how the policy language is paramount. So the determination of the cause of the interruption will be important, A, to allow the existence of causation, to allow the existence of coverage, but more importantly, for those of you that are aware and know insurance law, for the purpose of any aggregation. Now, depending on the policy wording, the assureds may have wanted to avoid all their losses being aggregated as a single claim. They may have wanted to have different events classified as different claims for reasons such as the deductible or a cap in what they could get as compensation under the policy. Remember the 9/11, the Twin Towers, there was a huge issue as whether the first plane hitting the tower and then the second plane hitting the tower was one event or two different events, because there was the issue of the deductible and there was the issue of the cap in the compensation. So on the one hand, if you had two events, you had two deductibles, but at the same time you had two different caps, so different compensation. Now, so the advice is to the policyholders that were close to renewal at the time that COVID-19 claims started, look at your policy, talk to your insurer, and make sure that when you renew it, that you renew it in the correct way so that you will be covered also afterwards. But of course, the insurers were not very happy with that. They started putting exclusions. They started saying, hang on a minute, this is not covered anymore. This is an uninsured loss. I cannot cover that unless I make the premium double or triple or 10 times more. I give you an example. I work at the University of Exeter. I travel. We have a group insurance policy for health, accident, and any sort of business interruption, any sort of delay, loss of equipment, etc. Automatically, Aviva, one of the insurers, last March said, A, travel is forbidden unless you repatriate. So I went to Greece having the Greek passport and stayed there until September. I was allowed. So A, you are not covered unless you repatriate. B, if you travel, you are covered for anything else if you fall ill except COVID. So this became a big issue. And I just talked about different, this was a personal group policy for accident and health mainly, but it shows how the problem was exacerbating starting from last March. And if you want to claim for business interruption, you would have to prove what income you had loss of income in the last months and what income you had in the previous financial year. And so we saw the emergence of a lot of case law in different jurisdictions. And as I said, in the US, initially the courts rejected the claims for business interruption. But in Paris, in April 2020, a court of first instance ordered AXA to pay 2 months revenue losses to a restaurant owner who was the policyholder of a business interruption insurance claim and where the insurer had denied to satisfy the claim. So the restaurant owner went into court. And this was the first time that we had a court saying, well, I'm sorry, COVID-19 is providing coverage for business interruption. You have to pay. And this sent shockwaves of terror to the Lloyd's market, to England, because you can understand, being the largest insurer in the world, they thought, what is going to happen now? And in other jurisdictions, we had different approach. We had a dispersed, let's say, approach as whether this would be allowed or not. And what the Paris AXA ruling did is that it was thought that it would potentially open the door to a wave of similar litigation because the court said that the administrative decision to close the restaurant qualified for insurance cover as a business interruption loss. So the actual lockdown measures were classified as equivalent as sustaining physical loss or damage to property, which then would trigger the business interruption claim. But I put here some case law from the US. So in the US, we have a lot of development, different development at federal and state level of how the case law has gone. It has gone both ways. So in Malestone versus Lightning, the first case that is in the slides, the Ohio court found that mold did not constitute, that's pre-COVID, but it shows the precedent that is there and what would be also used in the COVID scenario. So the Ohio court in Malestone found that the mold did not constitute physical damage to property, and therefore it did not trigger the coverage for the policy. And in Universal Image, the court said that we have to have tangible damage to property to trigger the policies that require, that would then be compensated. And here we had the assured trying to be covered because of water that went into the building in Universal Image production case and subsequently created a pervasive odor, mold, and bacterial contamination, both visual and aerosolized. And the court looked at the various split decisions in the country's various jurisdictions at state level and said that the mold and the water related damage did not trigger the coverage because in Universal Image, the court said you have to have suffered structural and tangible damage to the insured property rather than have intangible harms such as strong odors and the presence of mold or bacteria. So they thought that mold, bacteria, and odor is intangible evidence. So the first conclusion already from these two first cases is that under Malestone and Universal, COVID-19 which would exist in an insured property. Let's say the workers went in, they were not tested before, they touched the surfaces were contaminated, would not qualify as physical damage. But we also had in the US less strict standards. So we had Gregory Packaging case where the presence of an unwanted substance was found able to trigger coverage for policies requiring physical loss or damage. And Gregory Packaging is important because it gives the weapon to the policyholder for a more liberal definition of what physical damage is. But it's not a silver bullet protection still, but it's better than before. But it provides a better threshold. Now, as this case law existed and as it started evolving in the US, the companies would continue to file business interruption lawsuits for claims arising from state and local government shutdown orders. And if I give you very briefly some sort of litigation analysis, until October 2020, we had at least 1,250 cases filed nationally in the US. After October, the weekly rate of the new cases declined, and all from those cases, more than 1/3 had been filed by bar and restaurant owners. And of course, as I said before, initially, we had, and throughout, and more as we moved into the summer of 2020, we had very negative rulings for the policyholders. So basically nearly 75% of the cases have resulted in dismissal of the policyholders' claims. But we had 2 cases in New Jersey and in North Carolina which have found in favor of the policyholders. So Optical Services and North State Delhi, it was found that the physical loss or physical damage was not required. So you didn't have to prove that. They said we have, the court granted summary judgment in favor of the policyholder for the restaurants, concluding that actual physical damage to be proven was not required under the policy at issue. And they stated, if you read the judgment, that we have a major event interrupting the revenue and the operation of the businesses, and this is enough to prove the coverage. Now, these are just 2 cases from the sample of case law I looked at, but it shows the tendency of the jurisprudence so far. You have to think about why the courts are so rigid, because they don't want to see an insurance market collapse, because if everything starts being satisfied, then you will have an event that is uninsurable or a collapse of the market, because the reinsurance will not be able to allow the coverage of these, let's say, of these claims that have been satisfied, that have been ruled to be satisfied for the policyholders. So the amount of litigation that COVID-19 is creating, I read somewhere, and I thought of saying this to you, is equivalent of a major hurricane making landfall every month, because this is an ongoing situation. And in the States, in July 2020, we had a state court in Michigan which ruled in favor of the insurance in the Gavrilidis management case. And this is the first substantive ruling of COVID-19, because here the insured argued that the exclusion of the virus, there was an exclusion in the policy, did not apply because loss of access was caused by the government orders. And the court said that coverage applied only to actual loss of business income sustained during a suspension of operation, and that this suspension had, as I have said before, to have been caused by direct physical loss or damage to the property, and that they thought, again, as in the previous cases in Mastelone and in Universal Image, that this direct physical loss was not tangible in order to be substantiated. And then at the other side of the ocean, in SCGM versus Lloyd's of London, we had a Lloyd's policy which contained a pandemic event endorsement, and Lloyd's has taken the position that COVID-19 was not covered under the pandemic event endorsement. So there was an endorsement for pandemics, but because COVID-19 was not mentioned, they said it wasn't covered. Well, I'm sorry, it couldn't have been mentioned. I disagree. I am from the beginning on the side of the policyholders. And I have also argued in articles that state aid mechanisms should be in place, because of course the market cannot respond. The market had to be helped by state aid mechanism also post 9/11 or even after Hurricane Katrina. So, but that doesn't mean that we should leave, the assured uncovered, and we should create this. Then why should we have insurance if it's a priori defined that there will be no coverage? So you can understand that there was a lot of uncertainty, and to dissolve this uncertainty, the regulator in England, the Financial Conduct Authority, decided to bring for the first time a test case in the courts. Now, what this test case meant was that 6 insurers went into the court on a test case on a hypothetical scenario, but for COVID-19 claims for business interruption, but they agreed that whatever the ruling would be, the final ruling, because it then went into the Supreme Court, this would be binding for them for later decisions. So the first decision was adjudicated, the first judgment in mid-September 2020. And as I said to you before, we have extensions in the business interruption covers for denial of access or for disease clauses or for trends clauses, which I will explain in a minute. And the High Court said that most of the disease clauses in the business insurance policies cover losses by infectious diseases, such as COVID-19, but only some denial of access policies would provide cover. So whoever had a business interruption policy which was based on a disease extension was okay after the September judgment. So they would have to demonstrate that they were, they just had this type of coverage which automatically was triggered, and they didn't need to point to specific local outbreaks as the cause of their losses. But denial of access, because the court said that only some denial of access policies provided cover, was a bit more problematic at that point, because it would be more difficult to establish cover, because they had to show that the government action was in response to the COVID-19 outbreak within a specific radius in order to deny them to access the premises of the business. Now, the way it is, the system, the judicial system is in the UK, you have to ask for leave, you have to seek permission, to seek leave to appeal. And the High Court, so the insurers, 4 of the 6 insurers sought leave to appeal to the High Court judgment. They wanted a final judgment at the 3rd level at the Supreme Court, and the High Court allowed the appeal. And what was discussed in the appeal was whether prevention, denial of access, interruption, and inability required total closure of the premises or just partial closure, because we had businesses that had partially closed, with either in terms of how they operated or the space that operated. And what was important was that these 4 insurers, they sought permission to appeal to the court's finding that the decision in Orient Express, which I will mention in a minute, I'm sorry, I didn't change the slide, hadn't been followed. So in the High Court judgment, the court said that this does not apply the Orient Express Hotels case, but if it was to apply and if it was to be used, then it should be changed because it was bad law. So the Orient Express was a case where the Orient Express Hotel in New Orleans claimed against its business interruption policy following the damage from 2 hurricanes, the Hurricane Katrina and Rita, very well-known hurricanes, which resulted in the closure of the hotel for months. And the High Court and the Court of Appeal concluded, it's a very peculiar way, I tried to make it very easy for you to understand that the hotel would have suffered business losses even if it had not been damaged, as the city in which it was based was forced to shut down during the hurricane. So what they said is that because the city was closed down, total inoperation of the city because of the hurricane, there would be damage anyway, but this didn't constitute business interruption, didn't actually constitute physical damage. So a very, very peculiar construction of the judgment analysis. So the hotel was treated as if it was an undamaged hotel in a damaged city. And what that meant, practically speaking, because we need to know the practical scenario, the practical effect is that they could only recover a very limited amount under the policy. So in the FCA test, the Lord Justice Fox and Justice Butcher, they concluded that the Orient Express case analysis was of no relevance, and it was wrongly decided in any case. So they contested that. And by doing that, this is why the 4 insurers appealed in order to have this overturned. They didn't want the Supreme Court to say that the Orient Express case is wrong, because then they would have to pay to a greater extent. And we see that already from the High Court level, the construction is more sympathetic to the policyholders, and it paves the way for more general payouts under the so-called trends clause, which is a clause to assess the extent to which a business has been financially affected by reference, as I said, to its trade during the period and to its previous financial books. So we had the Supreme Court hearing, and on the 15th of January 2021, the Supreme Court delivered its judgment and ruled that cover may be available also for partial closure of premises. So it extended what the High Court had said, not only full closure, but also partial closure, and for mandatory closure orders that were not legally binding. That was very important. I will explain in a minute, because in any case, the loss would have resulted from the pandemic. So this is a very important decision because thousands of policyholders will now have their claims for coronavirus-related business interruption losses paid. It's not very good news for the insurers, but again, it's not like there is a blanket decision that everything is to be paid, but it is a better decision for the policyholders. So let me already make some conclusions, which are not just conclusions, they are more critical analysis. First of all, the legal landscape for insurance coverage for losses due to COVID-19 pandemic is continuing to shape. It's an evolving trend. Nothing is finalized so far. Today, the 22nd of February, it's still 2021, it's still evolving. Many standard policies contain exclusion for viruses, others not. Now, the case law has been a bit better in accepting the need for compensation, but the attitude of the courts, as we see, differ per case and jurisdiction, and the case law is evolving alongside the pandemic per se. Now, as my talk and my study and research so far has allowed me to conclude, in the USA, the courts have started allowing such claims to flourish, and they have started granting policyholders judgments in their favor, whereas before, let's say, the summer of 2020, they were very hostile towards the policyholders. But in Europe, there's a different, let's say, landscape, and the situation is still dispersed. So the general trend is to accept to satisfy the COVID-19 because business interruption is found as casually linked to the claim. But in the UK, there was the need for such a revolutionary, I would say, approach from the regulator to allow the market not to collapse and to guide both the insurers and the policyholders. And this is the role of the regulator. They have to intervene in order to make things straight. And there was an eagerness to set the standards to avoid this collapse, as I said, and to serve both parties, both the companies and the policyholder fairly. So what the recent UK Supreme Court ruling teaches us is that you can have valid claims if you prove the threshold, and sometimes the payout will be higher, sometimes lower. You can have cover which is available for partial closure as well as full closure, and for mandatory closure orders that were not legally binding. And what the UK Supreme Court ruling said is that the business interruption policies were all triggered primarily by material damage to the premises because of COVID-19, but it was never suggested that COVID-19 damaged the premises. It was rather an external factor that led to the enactment, to the activation of the coverage threshold. And because the policyholders usually in such policies rely to a series of extension triggers, such as I said, disease clauses, denial to access clauses, and hybrid clauses, business interruption was validated. And the court said that interruption doesn't require complete closure, and it preferred the view that cover is required as long as the illness is proximately caused, the illness meaning like if they had a disease extension on top, attaching to the business interruption policy, then this illness, this disease trigger was satisfied when we had an outbreak within a radius that is acceptable. Usually it's 25 miles. And the sole question was whether this local outbreak had caused the business interruption loss, because not necessarily you had the premises contaminated, but you had a closure. And a trigger for those who had access clauses, denial of access clauses attached to the business interruption policies, they had to prove that there was prevention of access to the premise or inability to use the premises because of the restrictions due to the emergency that, that occurred. And the court also said prevention and inability to use was more or less satisfying the requirement. So what the requirement under the access of denial clauses was that the assured could not use the premises for either a part of the business or for a part of the premises, so a part of all the premises for a part of the business of the operation, or a part of the premises for all the operation. And they also said that the meaning of the phrase restriction imposed by public authority refers to mandatory rules derived from legislation, so instructions issued by a public authority, such as all governments, local and nationwide measures that, even though they don't have the force of law, they prevent the operation. So the important thing is to understand that the test was whether there was an interruption without the need for recourse to legal powers on the basis of these instructions issued by the authorities. So if the government says stay home, don't go out, translated into don't go, stay home, don't go out for very, very small and vital to your survival operations, all shops are closed, therefore you can't go into the shops. This meant that the instructions to stay at home were within the clause, even though they were unenforceable. So the restriction also was aimed to third parties. So the Supreme Court went very much in detail and said that even though it was aimed at a third party, so it wasn't aimed at the premise or at the clients of the premise. Let's say I have a company, I have a shop, I have business interruption policy. The public is the third party. The public is not allowed to go out and visit my premises. Therefore, if the public are required to stay at home, this is a restriction of a third party, which is enough to trigger the insurance coverage. And they also said that in the Orient Express, we had an insured peril and an uninsured peril. It doesn't matter that we have two insured and uninsured concurrent events. So long as there is no exclusion, we have coverage. So they said that the correct analysis, the way the Orient Express should have been decided was that there were business interruption losses caused by the damage to the hotel and the damage to the city because of the hurricanes. It doesn't matter if the damage to the hotel was not immediate. So long as it was not excluded, it should have been covered. And then last but not least, the court said, if we take the Orient Express logic and apply it to the COVID claims, 19 claims, we have a policy that responds to interruption within an illness which is sustained within a specified radius. It's enough to show that this illness, the virus, for example, COVID-19, has occurred. And they also said, if we have a lockdown policies, the lockdown measures are concurrent causes of the loss. So even if they're not direct causes of the loss, the fact that they are not excluded is enough to trigger the clause. And they also referred to the third way that these extensions apply to business interruption policies. And they said that the trends clause all they are doing is that they are quantifying the loss to give the policyholder the better protection. So they are trying to help how to measure the loss because you have to understand that there was no data here. We had an event that happened for the first time. So usually in business interruption claims, if you have a financial loss or something, a flood, whatever, you have previous statistical actuarial data. Here, there was nothing. So this was one, let's say, trick for the insurers to pay less. They said, well, I'm sorry, there's no data. I cannot quantify the loss. A loss which is not quantifiable is very difficult to assess. So the Supreme Court really did a great job. I think the FCA did a great job in introducing this revolutionary test case, because I think, first of all, the market will be helped in order not to collapse, and also fairer adjudication of claims. Insurers will start paying because they will understand that it's not in their interest to go to court. And even if they go to court, then there will be guidance for fairer adjudication. So I'm sorry if I have spoken a lot. I tried to give you a thorough analysis of how the landscape for business interruption claims and the insurance implications from COVID-19 have evolved. Thank you. I'm open to questions now.
Thank you very much for this interesting presentation. Now, please, all are welcome to share their questions or comments and contributions, of course. I can see, let me check the, Yavuz Aslan.
Yes, I had a question.
Yes.
Yes, please. Yes, please. You have the floor, please.
Thank you, Professor, for your very clear presentation. My question is related to the scope of damages arising from the COVID pandemics. So COVID-19 affects the businesses over a long period. So unlike any other risks, the loss suffered does not arise of a single event, and it affects the prospective or hypothetical interests of the businesses. For example, in the AXA case, you talked about a restaurant.
Yes.
And it's not very easy to calculate the loss occurred to the restaurant, because you cannot really show the interests that was suffered over a long period. So what methods do the courts use to determine the scope of damage suffered under a policy according to business interruption? Do they look at the previous year's interests to calculate the damages suffered by a restaurant? Because it's not one single event.
Yes.
And are there special provisions in the policies? If yes, are they adapted or appropriate to calculate such damages? And where does the discretionary power of the judge come into play at this stage?
Well, it all depends. Thank you for your question. It all depends on how, this is why I said at the beginning that the policy language is paramount, is of great importance. So in a lot of policies, business interruption policies in England, you have the so-called trends clause. And what the trends clause, as I said in the end does, is that it allows the sum to be amended, the sum to be compensated, to be amended to reflect any special circumstances or business trends affecting the insurer, the business, before or after the loss, so that the final sum to be adjudicated is a sum that would have been reached had the damage not occurred. So if you have a policy which has this so-called trends clause, the role and the work of the judge becomes easier. If you don't have such, because you can have different sort of policies in different jurisdictions, what the judge will look at and what the policyholder needs to do is first to look at the wording, but also try to bring some evidence, let's say accounting evidence of what its loss was in the months claimed, what its previous year's income in similar periods was, although this cannot necessarily be the best compensation. But as I said before, that we have to find a way to quantify the loss in the most objective way, both for the assured and the insurer, both for the policyholder and the insurer. So I think that in England, we have these trends clause, which allows this variation. If in other policies or in other jurisdictions you don't have that, I think that the judge will have to improvise on the basis of previous, let's say, balance sheets from previous financial years, and on the basis of evidence that is produced for the current period. So if you have, let's say, very little, then you, or nothing, because you have been on, off, opened and closed as a restaurant, because you talked about a restaurant, then you have to provide this evidence. I don't think that there is a straightforward calculation. There's no formula. It's just a matter of interpreting the contract.
Thank you very much, Professor. May I go on with another question?
I am happy to take it if the moderators are okay.
May I just extend the question?
Yes, please.
So, Professor, do you remember the breakdown of the total loss as set out in the AXA decision? So how did the court rule the total compensation?
In the AXA decision, they had in front of them, the 3 months losses that the claimant submitted to them. You have to understand that the courts cannot adjudicate for anything else than what is presented on them. So whatever the restaurateur asked, he got from the court. And he asked for the how he calculated the 3 months closure, I think March, April, and middle of May, I don't know, from the time that this first lockdown, extended lockdown happened. I don't know how much it was in France. I think it was basically 2.5 months, maybe. But what the restaurateur asked for, he got from the court.
Thank you very much, Professor.
Thank you very much. I see that Professor Aslan Erbaş Aşıker is raising hands. So please, Professor.
Thank you very much for this very interesting and introductory presentation, Professor Noussia. I would like to ask about, you mentioned in your presentation that especially during the contract renovations, the insured must look at his policy, whether the risk is included or not. And I would like to ask whether this also be considered under the duty of the insurer, under his duty of information, whether the insurer should also emphasize the risk exclusion. Thank you very much.
So if I understand well, you're asking me at the contract renewal stage, whether the insurer had a duty previously or for the new contract?
For the new contract, actually.
Well, the insurer has a duty to inform and has a duty, as you know, under the insurance, the IDD and directive, they have an extended duty to inform and to advise accordingly on what is the best coverage. But that said, that doesn't mean that they are not able and they don't have the right to assess the circumstances and to say, well, hang on a minute, from now on, in order to claim, I need to have X extra premium in order to give you the same cover, or in order to expressly include in the cover the COVID-19 pandemic claims, whatever claims these are. So the duty is there, but for the policyholder, the obligation the obligation of the insurer to inform the policyholder is there. But at the same time, the duty, the right of the insurer to ask for extended premium than previously because of this, you know, first in the last 100 years event is also present. And this is the reason why there was this huge danger and still exists that we would go into, you know, into a dead end, you know, and we would have in some cases the events not covered. After floodings, for example, floods are not a new risk. So after floods in certain areas, if you buy property in that area, there may be that insurers do not insure you for flood risk anymore. And it is their right to do so, because they may say that the flood risk is so high that it is unquantifiable, the loss, and therefore I cannot offer you this risk. Or they would offer the risk and they would offer the coverage of that risk to a very high premium. And that means that the policyholder is unable to pay this premium. So again, we reach the same result. This is the reason why I said, I think that state intervention through schemes similar to the ones that were triggered post 9/11 should be put into place. And you see also, you see the financial aid mechanisms that were triggered nationally and internationally from various, let's say, organizations and institutions. I hope I have answered your question.
Yes, thank you very much. That was exactly what I was asking. Thank you so much.
Thank you very much. So do you have any other questions, comments, or contributions? I'm checking the chat section and also anyone raising hands. I guess no. I would like to, if we don't have any other question, I would like to give the last word to Professor Başak Baysal, the Dean of the Faculty of Law. Please, Professor.
Thank you, Aslı. A few words, but first of all, thank you very much, Kyriaki, for accepting the conference to make a conference with us and for this wonderful speech. And I hope to see you very soon in Istanbul. It's a kind of surprise now, but we don't know the results, but we are looking forward to have that. And maybe we will have another chance to work together in Istanbul. But in any case, I know that we will continue. I mean, we have a friendship since now 15 years now, I think, yes. Since Hamburg, and it's for sure that we will meet again after this crisis and here in Istanbul or in Hamburg or anywhere else. But I sincerely hope that we will have you as a professor in Kadir Has University also for some years. We are waiting for the results. And thank you again for the wonderful speech. And I hope to see you very soon.
Yes, thank you. Thank you all. I would like to specifically thank you, Başak, in your capacity as the Dean, and also Professor Nilay Arad, and everybody else that was present. It was a pleasure to give this talk today, and I look forward to more collaboration between us. Thank you very much.
Thank you.
Thank you. So thank you, dear professors, dear colleagues, and dear students for participating. And thank you very much, Dr. Noussia. So we are kindly closing the session, but we will continue with the seminar series of comparative law. So hope to see you again soon.
Yes. Can I ask something?
Much.
Will this be linked?
Yes, sure.
Will there be a link for YouTube? Because I'd like to share it with my students.
Yes, there will be a link. I think in a few weeks, we will send you the link, the YouTube link.
Thank you so much. Thank you again for today's participation. See you soon.
Thank you. Thank you very much. See you. Bye.
See you. Bye.